Hello, everyone, and welcome to another episode of the Perfect RIA podcast, What Works Wednesday edition. I'm your co-host, Matthew Jarvis, and with me today is Chris Stanley from Beach Street Legal. Now, Chris, I think you and I might have crossed paths at some prior event when you were giving a presentation on compliance, and I was like the one guy in the front row taking vigorous notes and asking questions. So welcome to the podcast. Excited to have you here.
I appreciate the invite, and yes, it definitely takes a rare breed to attend the compliance session, so thank you in advance for those that are listening.
Yeah, Chris, take just 1 second and tell us a little bit about the work that you do in the RIA space or in the financial advisor space, just to give context for our listeners. And then I'd love to jump into things that we should be thinking about from compliance, things that may be common mistakes or myths that people think about compliance, and really just run from there.
Absolutely. So Beach Street Legal is a law firm and a compliance consultancy. We focus exclusively on RIAs, so we're pretty narrow in that respect. And I would say our core practice areas involve day-to-day compliance, just corporate legal work, and also M&A. So we do a fair amount of work with respect to transactions in the M&A and advisory space as well. To answer your question, I think one of the common misconceptions or the common fear points is frankly just being paralyzed by not knowing where to start with compliance, and also just not applying like a systems thinking approach to compliance. And I would say, just from a day one perspective, organization is your friend. Where are your files? How are they tied together? How are your workflows connected? What sort of technology can you avail yourself of? And if you can really distill and break that down operationally, I think it makes the compliance life of a CCO a lot easier.
No, that makes a lot of sense, right? And there's so much technology available. And I think you and I had chatted before the show or in our notes back and forth about that the SEC isn't necessarily some this like super scary monster under the bed, right? And to your point, the more record keeping you have, likely the better off you're going to be.
Yeah, the way I try to position the SEC exam experience to advisors is, at the end of the day, it's a books and records test, if you will. So step number one, I would say, is to go to the record keeping rule in the Investment Advisors Act of 1940, if you're SEC registered, or for your particular state, if you're state registered, and just literally run through it and say, okay, am I keeping all of these records, or are there any gaps? Because that is the universe of documents that the SEC or a state regulator can ostensibly ask you to produce. So problem number one is, if you're not keeping those records, like, you're not starting off on a great foot. Step number two is, are those records organized, readily accessible? Are they complete? Are they a result of a batch scan job where it's diagonal and half the page is cut off, And so, organization and completeness is really just the foundation. And honestly, if you're doing that, you're doing a lot of the work that's going to be expected of you of an SEC examiner. Because if you start out saying, I don't know what that record is, or I don't know what you're asking about, or I can't find it, not a great look.
Yeah, no, and a good point about if you're state registered. Each of the states have a different requirement. I remember years ago when we were state registered in the state of Washington, they were doing an examination. Yeah, Washington's its own thing. They were doing an examination, and they said, hey, we need all of your financial records, like your business financial records for the last however many years they wanted. And thankfully, my bookkeeper had kept all those, because I'm thinking, like, I don't save those receipts from 5 years ago. And they said, no, we can, in Washington, we can see anything we want to see. We want to see those things. What are some examples, Chris, that you see where people are missing documents? Like, what's kind of common areas that we just don't think about?
So it's interesting you brought up financial statements, because I commonly see that, at least at the state level. And the SEC will likely request those documents as well. So basic financial statements like a balance sheet, an income statement, general ledger, trial balance, et cetera. And at the state level, they can be a little bit more nuanced in terms of being gap specific, especially if you bill in advance. They don't like to see that income recorded 100% on day one. Has to be sort of prorated and fully earned at the end of the billing period. But as far as other documents that we typically see advisors missing out on, it's not necessarily that just the core documents are there, but it's that if your compliance manual says we are going to do A, B, and C, we may be doing A, B, and C, but if you don't have the documentation to support it, then it never happened. In other words, it's the old regulatory adage, if it's not in writing, it never happened. So I really encourage advisors to show their work, get credit for the things that they may be doing on a daily basis that they may not be recognizing sort of counts in the compliance bucket, if you will. So if you have a QC process where, just to use a simple example, you're making sure that as part of the client onboarding process, the client agreement is fully signed, it's dated, the fee schedule is accurate, it matches what's in the custodian's platform or the portfolio accounting system. Like technically, that is a compliance test that you can count towards making sure that fees are being billed accurately and your records are being completely maintained from an advisory agreement perspective. So again, show your work and then test yourself over the period of a couple months, maybe a year, where you look back and say, let's pull a sample of client agreements that we signed in Q2 just to make sure they're all there, they're all complete, et cetera. And sort of, make sure that you're not just taking your processes for granted.
Yeah, sort of like an iteration of the dishwasher rule, show your work, but for the SEC. I remember we had an SEC exam several years ago, and one of the things they wanted was documentation of our investment process. And so I explained it all to them, and the examiner's like, well, that's really cute. Show me the documentation of it. And I said, I never kept that stuff. Like I looked at the Morningstar stuff, I looked at this different analysis, and he says, well, hey, listen, I guess, Chris, to your point, if you don't have documentation of, I can't just take your word for it. And so they put that on their deficiency letter. It wasn't a big deal, but they say, listen, going forward, you have to have documentation. Kind of to your point, if you're doing quality control, you better document that. If you're researching investments, you better document it, please.
And what I'll just add to that, it's equally as important to do what you're going to say you do in your compliance manual, but it's also important not to overcommit in your compliance policies and procedures manual. So it's as much of what's in there as what doesn't necessarily have to be in there. So if you have provisions regarding wrap fee program obligations, but you're not a wrap fee program sponsor or participant, carve those out. If you have entire sections on proxy voting, but you don't vote client proxies, take it out. If it says you're going to do a review once every 2 weeks of your client accounts, but you're really doing it monthly or quarterly, like make sure that syncs up. So in other words, don't make your life more complicated than it needs to be from a regulatory perspective by, shooting everything over the moon if it really doesn't apply to your firm, because that'll make your life easier as well.
Yeah, boy, this really speaks. And you mentioned this earlier in the episode about having processes and systems in place for that. These are really easy things to forget, right? It's easy to think, oh, I did that compliance review the other day, and the other day turns into 3 months, 6 months, 9 months, 4 years. And then it's the SEC exam, and now you're trying to backfill, which isn't going to work well for you.
Yeah. And I encourage, especially newly registered advisors or those that are kind of approaching that hockey stick moment in their growth, is solve those little problems, those little organizational kind of nudges early. It's the old analogy of the rock and the shoe, right? You can keep walking and bear it, but like if you don't take that rock out, it's really going to cause like a blister or a bruise. So, take a pause. It's never fun to spend time going through and organizing files or checking your compliance records, but the workload required to do that before the hockey stick inflection point is a lot easier than trying to use another analogy, change the wheels on the bus while you're already racing and onboarding a bunch of new clients, hiring advisors, growing AUM, et cetera. You're just compounding the problem that you could have addressed 3, 4, 5, 6 months ago. And so the earlier you can kind of get your organizational foundation underneath you, the better off you'll be for the long term. And you can iterate over time. That's fine, but just get the basics in place early as opposed to later.
Yeah, that makes a lot of sense. I guess I hadn't really thought about it if you were starting your RIA from zero, like day one in the industry, you're starting an RIA, which I think you and I had mentioned, we probably met at the XY conference, right? So a lot of people that are starting day one, I had started in the BD space, which was really common for my generation of advisors. And so we were already used to the record keeping, right? Inbound and outbound correspondence and a compliance folder and a marketing folder and all these things. So when we shifted over to RIA, like we already had those systems ingrained. But I could see how that would be really easy. Like, I don't know, I don't maintain an outbound correspondence file. Oh, you need that. Or, hey, the thank you note that I got from a client, that needs to be put in a file too. Like that's got to be imaged in as incoming correspondence.
Yeah. It's one of those things where just take inventory of what you have, what you don't have, and build off of that. And to your point, I'm glad you brought this up for advisors that are maybe transitioning from a broker-dealer environment to an RIA environment. There is a lot of stuff in the broker-dealer world that you just don't have to deal with in the RIA world. And so just making sure that you're not carrying over excess baggage into the RIA world. And again, doing things that you don't have to, or that may confuse a client or confuse a regulator as to what sort of capacity you're acting in.
Sure. Chris, talk to us a little bit about RIAs working with a compliance attorney like yourself, especially, like I said, people that are in the BD world that are thinking about leaving. At what point in that thought process should they be reaching out to someone like yourself?
So, I mean, my answer is obviously biased, but I can say generally speaking, with respect to whether you work with an attorney or a compliance professional or some combination, I can say that from our profession, it's better that we're not surprised, or it's better if we're not brought in too late to try to clean up a bunch of mistakes or perhaps decisions that were made that need to be rectified. Usually that results in more time, more cost, and just more clunkiness to kind of making a smooth transition. So even if it's involving somebody just on a pure hourly basis early to say, hey, I need the second set of eyes, I want to bounce some ideas off of us. It's making sure that your trajectory is not just 1 degree off from the beginning, because at the end of your course, you're going to be way off where you need to be. And so I realize it's kind of a vague answer to say earlier rather than later. But as soon as you start to put those kind of concrete business plan steps to map out and build your team to help you with the transition, that's ideally when a compliance professional and an attorney can get involved, because they can help set the stage and hopefully help avoid mistakes that might lead themselves to be difficult to unwind the further on you are down the line.
Yeah, I mean, I can think of a real simple example with that would be if you found some kind of boilerplate advisory agreement that you had all your clients sign, and then you went back and realized that it didn't meet your state's requirement, or any number of other examples. Now you've got to go back through and repaper all of these.
Right.
Go ahead, please, Chris.
Yeah, and I'll just add a couple other instances involving advisor transitions would be, does your state even permit dual IAR registration if you were planning to be duly registered with 2 firms at the same time during a transition process? If you are subject to some sort of a restrictive covenant with your current employer that requires you to give 30, 60, 90 days advance notice before you leave, you should be aware that that provision is in your contract, so you can build that into the sequencing and when certain triggers can be pulled for the transition process. So yeah, there's just a few, our job is to issue spot and educate and advise.
Sure.
Here are the decision points. Here are the risks. Here's the pros and cons of the various approaches that are available to you. Let the RIA owner make informed decisions and then advise along the way.
Yeah, that makes a lot of sense. I always, when I talk to advisors that are thinking about leaving the BD space or the wire space or whatever it is, I always recommend reaching out to counsel immediately, if only because compliance can seem like such a scary thing. Now, there's a lot of contractual obligations. There's a broker protocol. There's all these kind of things. But for a lot of people, compliance is this big, scary thing. And they have in their mind that the broker-dealer's compliance department is like these warriors defending the castle. Right. And they have a role, and that's not to diminish the compliance department. But in my experience, it's not quite as scary as sometimes people believe it is.
Yeah, I completely agree. And I mean, I'm a former chief compliance officer myself.
Oh, sure.
And so I was at a large asset management firm in my prior life. And, we would be on the butt of the jokes as far as being the no department and all of that. And to be honest with you, in certain instances, it's kind of a reputation that's earned. And I've certainly encountered firms where that is like the de facto response. And again, that reputation is earned. But I've been trying to reverse that, that bias and that assumption and really talk advisors down from that scary ledge to say, yes, compliance has a bad rap. Yes, there are many landmines that you can run afoul of, but let's try to simplify. Let's really hone in on your particular business models and not worry about all the other conceivable risks that might apply to another advisor that doesn't have the same business model. And really to say, look, let's try to distill down what the most important core areas are. Are you acting as a fiduciary to your clients? Are you acting in their best interests? Are you complying with the spirit of the regulations? Are you keeping all the records that you're required to keep, like we talked about earlier? If you're doing those core functions, like you're 90% of the way there. And so I think just kind of breaking that down for advisors and realizing that, look, it may seem scary, but it doesn't have to be, especially when you're organized. Organization is empowerment, right? And so that can go a long way.
It really can. Chris, I'd love for you to step back into that role that you had when you were a chief compliance officer in a big asset manager. When I talk to advisors that are in big wires, that are in big organizations, and a lot of times it's that, like you said, the butt of the joke, like it's this adversarial relationship between them and compliance. And I've always advocated when I had compliance officers and just when I'm talking to advisors to really approach that from a collaborative standpoint, right? So I can't imagine, but you've sat in these rooms, so you can let me know. I can't imagine that the compliance guys are sitting around drinking pickle juice thinking like, how do we really make life miserable for the advisors? Like, let's shut down every single thing. And so I always told advisors, again, I'd love your thoughts here. Hey, if you're going to try something that's not being done by everybody in your organization, right? Go to compliance with, hey, I saw this strategy. I saw this idea. Could we collaborate on how this could possibly work within the realms of compliance versus, hey, I saw Matt Jarvis do this on the Perfect RIA. Why can't we do this?
The same principle applies to your CCO as it applies to the SEC, and that is that sunshine is the best disinfectant.
Yeah.
If you can be very transparent, involve compliance early in the process, you are likely to get a more dynamic response, a willingness to find a solution, and that collaboration. Whereas if you come to your CCO and say, oh, I did this a couple weeks ago, should I have done this? Like that puts the CCO in sometimes a really challenging spot, because if it was in violation of a particular rule or the firm's policies and procedures manual, then sometimes their hands are tied as far as what they can do. Whereas if you can approach them early, you may not get the response that you want, but at least you know from the CCO's perspective, oh, this is somebody that I can trust to bring things to my attention earlier as opposed to later, as opposed to somebody else who comes in after the fact is like, I need to pay a little bit more attention to that person and make sure they don't do the same thing in the future. So yes, earlier the better, work collaboratively. You may not always get the response that you want. But I think what I loved is when I got challenged by advisors or operational folks or marketing folks at our firm to say, okay, we may not be able to do it this way, but can we do it that way? Or maybe this way? Or what if we, ratchet down this part of it? And like, just bounce ideas off, keep the eyes, get to that right solution and that compromise that's workable for both parties.
Yeah, it makes a lot of sense. Chris, in our last couple of minutes, I want to draw just a little bit more of this idea that sunshine is the best disinfectant. And that's certainly a culture we've tried to create inside of our firm, Jarvis Financial, which is, hey, like if you see any kind of issue, let's use trade errors as an example. Like if you see something that you might even suspect might have possibly been a trade error, like ring all the bells, say something right away. There's this sort of temptation, like, well, I hope nobody notices this. Like, I hope nobody notices we got this like quasi client concern or this quasi trade error. But to your point, it's like, well, you got to, anytime you think you might even possibly have an issue, but you got to bring that to the surface right away. They only seem to get worse.
Absolutely. And what I would say is that is multifaceted benefit. Number one, from your perspective as the business owner, it's like, wow, my team is really on top of it. They trust me to come to me with these issues. They're open, they're honest, like they're on top of it. They're trying to keep the firm's best interest at heart by making sure there's not these festering issues. From an SEC examiner perspective, they're like, oh, wow, not only is it just the CCO sitting on an ivory tower trying to point down the compliance program enforcement, like the entire team is on watch, they're spotting issues, they're having conversations, they're running it up the chain, so to speak. And so the more that like compliance is instilled in the culture of the firm overall, like that's a great look from an SEC exam perspective. So even if non-issues are escalated, I would much rather have that than a issue that was actually an issue and not brought up. And so again, when I was wearing my CCO hat, I had the same message. When I advise advisors, I have the same message. It's like, no question is too small or too immaterial. Like that's how education works, right? That's how we provide that ongoing information about here's what applies from a regulatory perspective. Here's why what you brought to our attention is or is not an issue. And thank you, frankly, for bringing this up and having this conversation. Like it's a very good thing when team members do that.
Yeah, that makes a lot of sense. So Chris, in addition to shining light on things, right, that sunlight is the best disinfectant. I love that expression. What are some other action items that advisors should be keeping in mind, whether they're in the RIA space and they own an RIA or they're part of a firm, just anything that kind of comes to mind as far as action that people can be taking as a result of this episode?
Yeah. I mean, what I would say is that the core documents from a compliance perspective are your Form ADV, your compliance manual, your client agreement, and if it's a separate document, your code of ethics. Sure. Make sure they all kind of say the same thing and are not contradictory. And then number two, I would say, are there little incremental steps that you can take to be either more organized or more efficient or avail yourself of technology? In other words, is there that old filing cabinet that you've been meaning to deal with old paper files for years? It's like, okay, can you at least maybe scan a third of it? Can you maybe hire somebody that's a temp to go through and just plow through those things and get them digitized into your system? Is there one manual process that's just been nagging you and you do the same thing over and over and over again from a compliance perspective that perhaps could be solved through automation or recording a Loom video that you can share with a team member that you can delegate to do the task on your behalf? So in other words, like don't try to swallow the ocean in one fell swoop. It's just going to result in frustration. But is there one action item? Is there one efficiency? Is there one piece that can be organized? And hopefully you can avail yourself of the momentum that will result and you're prepared for an SEC exam when the time comes.
Boy, that makes a lot of sense. So tackle one of those items. Another example that would come to mind on that would be like file naming conventions. Sometimes I meet advisors and their digital files are an absolute mess. And so if the SEC said, hey, let's see the meeting notes from all of your client meetings or these 10 client meetings, and you're going to spend hours digging it around, that's going to be a headache for you, and it's not going to look good for you either. So
I love it. Yeah. I mean, I'm pretty retentive when it comes to like our file hierarchy, our naming convention, year, month, day, client name, yada, yada, yada. And when I see file names that are like final revised to parentheses 2 underscore red line, blah, 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 it just drives me insane. And that's just me. I realize that's my own issue, but I can say just from a search perspective, if you have Google Drive or OneDrive or, just folders on your computer, like realize you can build your file naming convention now to make your searching later in the process a lot easier. Like leave yourself those breadcrumbs. Don't make your life any more difficult in the future than it has to be.
Chris, that's awesome. I really appreciate your insights. Thanks for sharing your wisdom here. What's the best way for listeners to get a hold of you, kind of wherever they are on the spectrum? If they're saying, hey, I need to get a second opinion on this, or I'm looking for a full-time compliance officer or legal assistance, what's the best way to get a hold of you?
Yeah, the Beach Street Legal website would be great, beachstreetlegal.com. Feel free to shoot us an email at team@beachstreetlegal.com, and everything will be there. And I very much appreciate the time today.
Yeah. Thanks for being on. And a special thank you. I see a lot of the information you publish in the industry, whether it's speaking at the conferences or Kitsis articles. And I really appreciate that technical insight that you're kind of sharing. So thank you for that. Thanks for being on the podcast. And for all our listeners, until next time, happy planning.